Justice Antonin Scalia served on the U.S. Supreme Court from 1986 to 2016. But before he ever got onto the court, Justice Scalia warned us about the Article V defect. In 1979, the legal community had become aware of a defect in the Article V Convention Clause itself. American Enterprise Institute, also known as AEI, put on a group panel called A Constitutional Convention, How Well Would It Work? Included in the panel was Antonin Scalia. Here are his comments encouraging us to call for the Constitutional Convention of the People per Article V.
What's the alternative? The alternative is continuing with a system that provides no means of obtaining a constitutional amendment except through the kindness of the Congress, which has demonstrated that it does not want to have any other way to get a constitutional amendment. It could have cleared up a lot of these questions. It could have facilitated them long ago. For that matter, as was suggested to me by someone before the program, it could have provided an amendment by the normal amending process, which says that limited calls for state conventions are proper. That would have eliminated all doubt. But the Congress is not about to do that. It likes the power. It does not want to have amending power anywhere else. Now, I said I listed first among my the things I would like to have considered structural issues at the federal level. I don't have a lack of trust in the American people. I mean, you know, I'm the one up here who's least terrified of a convention. Yeah, we've come a long way. We've gotten over a lot of problems, but the fact remains that there is a widespread, deep feeling of powerlessness in the country. One sees it on every side with respect to many issues, not just the budget issues. The people do not feel that their wishes are observed. They're heard, but they're not observed, particularly at the federal level. Now, the Congress has come up with a lot of palliatives for this problem, among which I was on a panel a few days ago discussing the legislative veto, for example, which to my mind doesn't solve the problem at all. The basic problem is simply that the Congress has become professionalized. It has an interest much higher than ever existed before in remaining in office. It has a bureaucracy that is serving it. It is much more subject to the power of individualized pressure groups as opposed to the unorganized feelings of the majority of the citizens. All of these reasons have created this feeling, which is real and which I think has a proper basis, of powerlessness. One remedy for that, the one specifically provided in the Constitution, is this amendment process which bypasses the Congress. I would like to see that amendment process used just once at first. I don't much care what it's used for the first time. I think just having it used once will exert an enormous influence upon both the Congress and the Supreme Court, I think. I think we'll get the parameters established of how you do it, what can be done, and I think after that the Congress and the Court will behave much better.
Justice Scalia is a staunch advocate for the Article V Constitutional Convention for proposing amendments, and he's telling us it's the one remedy provided in the Constitution that provides for amendments that bypasses the Congress. Justice Scalia is acknowledging here that there is a defect in the Article V Convention Clause, and that the parameters need to be filled in, and that once you do that, the check and balance of the Article V Convention of the People can work upon the Congress and upon the Court. Now, please listen to Justice Scalia 35 years later, when he's asked what amendment would he recommend.
If you could amend the Constitution in one way, what would it be and why? Justice Scalia.
I certainly would not want a constitutional convention. I mean, whoa. Who knows what would come out of that? But if there were a targeted amendment that were adopted by the states, I think the only provision I would amend is the amendment provision. I figured out at one time what percentage of the populace could prevent an amendment to the Constitution. And if you take a bare majority in the smallest states by population, I think something less than 2% of the people can prevent a constitutional amendment. It ought to be hard, but it shouldn't be that hard.
35 years later, Justice Scalia's advice is to amend Article 5 itself. This is an acknowledgement by him that there is a defect in Article 5. He speaks about the high bar for ratification of amendments, but he still knows that the basic representation system needs to be set up. He's inviting us to study Article 5 more thoroughly. Nothing has changed from 1979. The parameters of representation are still missing from Article 5. Justice Scalia is warning us of the Article 5 defect. For the Article 5 Convention of the People to work as a check and balance, there must be clear rules of representation to begin. When the government knows that those rules aren't there, they know that the check and balance isn't there. If the Article 5 Convention Clause is not clear, there is no Convention Clause and no check and balance, and that's why we need to rebuild Article 5.